the views from there. Welcome. Thank you so much, John, for joining us today. John has an extensive experience in implementing workforce strategic solutions. He also understands quite a bit about sustainable businesses, and also does quite a lot of work in the sector when it comes to labor relations matters, and is also a representative through BUSA of Netlake. Thank you so much, John, for joining us. Welcome.
Thank you very, very much, Precious, and it's good to be with you guys.
I can't hear you. I think you either test the device on your volume or increase it.
Can you hear me now?
Try again, John.
That's very interesting. Precious, I was going to see if everyone...
John, I still can't hear you.
I can hear you fine, John.
Okay, would you please just come back? Yeah, I don't think anyone can hear you. Guys, would you please just...
I'm also able to hear John.
We can hear John.
Hidi, you were online. Oh, everyone say they can hear properly. So maybe the problem is on my side. John, please go ahead. I think the problem is on my side.
Thank you, Precious. I was getting worried there because I thought I was going to have a big problem here. But I just want to say thank you, guys. I know that it's late afternoon. I'm not going to keep you for too long. I'm just going to touch on certain key aspects of POPI and then end off with a bit of a to-do list. So, of course, the Protection of Personal Information Act came into full effect on the 1st of July. And if we just start off looking at organizations of any size, the core focus is, of course, on what they call data subjects. And data subjects are those natural people like you and I, or companies whose information you hold because you need to trade. So if you're an SME, you are working with suppliers, you're working with employees, and you're working with clients and customers. Now, those particular individuals, those organizations, it's their information that you are holding on to. You know, they're sharing their banking details with you, or suppliers, because you've got to pay them. They're sharing their pricing structures. You know, your clients are sharing confidential information with you. And of course, your employees are sharing confidential information. So ladies and gentlemen, the bottom line is the Protection of Personal Information Act says that you are the responsible party, because it's you that need these data subjects information to trade. You are responsible to protect that personal information. And of course, you can just imagine, even for small businesses, the large amount of information that you hold in your particular environments. So today we're going to just take a very quick look at the essence of POPI. I'm going to try not to bore you, so I'm going to move very quickly, and then we'll pull it together at the end. So ladies and gentlemen, effectively, when I look at POPI, there are two sides of the same coin. On the one side, when you protect personal information, the POPI Act says, please take a special look at your technologies, look at your systems, your programs, your platforms, and make sure that your technology is intact. In other words, your firewalls, make sure that your antivirus protections, your username, passwords, and any other related technical issues are intact. And secondly, they say it's not just your systems. You must make sure that your day-to-day conduct in your organization is secure. And of course, we deal with people. We're all human beings. We can make mistakes, and other instances you find people that intentionally disclose information. So we need to make sure we don't only cover systems, but that we empower, capacitate, and set certain standards for our employees and any other parties we deal with. So that's really the essence of it. I'm not going to spend too much time on this, just to share with you, colleagues, one of the biggest challenges is in fact systems protection. We can see 70% of all businesses in South Africa were subject to cyber attacks in 2019. That's 7 out of every 10 companies. And you might say to yourself, well, you know, we don't have these big databases and big systems. We're a small business. The bottom line, colleagues, it just takes one email with some suspect link and you're in trouble and someone's got you and they can hold you to ransom. So it's really important to just take a look at the POPIA Act and ensure that things are attended to. This is a case study that I normally look at, Liberty Life. It's not that I don't like Liberty Life, but there's so many learning value lessons out of this. But you can see here David Munro, the chief executive of Liberty Life, explaining how their systems were subject to a cyber attack. Millions of data subjects who held policies at Liberty, millions of data subjects, personal information, and family information was now in the public domain in unauthorized people's hands because criminal syndicates, you know, hacked their systems. And it's not the fact that they were hacked, colleagues, but Liberty came under attack because the Financial Mail said they were hacked again. So there seems to be a recurrence of poor IT practices. They also were taken to task because it took 2 days to advise their policy holders and other data subjects that information had in fact been compromised. And of course, at the end of the day, they ended up in a whole lot of trouble. Now, the point is, colleagues, not picking at Liberty, but imagine if this was your practice, your organization, your business. Imagine if somehow someone had access to your data subject information by virtue of an attack, or even your laptop getting stolen, ladies and gentlemen, and on your laptops, on your hard drive, you've got customer, client, employee, supplier information. You go to spa, you go shopping, someone steals it. You know, the question is, what have you done to encrypt or secure that information? So information regulator got involved, wrote an open letter to David Munro, the chief executive, and said, listen, answer these 5 questions. How did it happen? How many people were affected? What are you doing to prevent a recurrence? And have you notified the data subjects of the fact that they've been compromised? The point I'm really making is when we now move into the POPIA Act, if this was you, how would you respond to these questions? Now, the very center of this, if you want to make sense of POPI, ladies and gentlemen, you've got to understand the definition of personal information. The definition of personal information, as you can see, is it talks about natural people like you and I, and juristic people. So in other words, your data subjects whose information you hold in your business, they are information about employees, about client contacts or supplier contacts, natural people, but they would also include legal entities information, their banking details, their pricing structures, their confidential information. The next thing is they then go into these 8 subcategories and they say personal information encompasses in paragraph A, race, gender, sex, age, those things we become very familiar with, information about people's education, medical, financial, criminal, and employment histories. How's that, colleagues? Employment history. So immediately now I think, goodness, I recruit people, I do reference checks on them. What does this mean for me? I maybe in COVID-19, we collect certain information on our staff. What about that medical information? It also includes email addresses, telephone numbers, biometrics, even CCTV footage would fall within the definition of personal information because it can be linked back to an identifiable person, colleagues, and then private and confidential information, views or opinions, and so on and so forth. So when we talk about POPI, the first thing for today is the nucleus is the definition of personal information. So you can be sure if you're going to send an email, post on a social media platform, or engage in any form of communication or processing of information, the first question you must ask yourself is, am I dealing with anything on this slide? Because if I am, I'm now in the domain of the POPIA Act. Now, the next section, colleagues, is if the nucleus is the definition of personal information, right? If that is what you're dealing with, the POPIA Act now says the next wraparound, the nucleus is processing of personal information. And they're saying a chain is only as strong as its weakest link. So when you collect, store, transfer, and disseminate, merge, de-identify, in other words, the whole life cycle of personal information has to be secure and protected. It doesn't help, colleagues, if you collect information from data subjects and you make sure it's done appropriately and in line with law, and then you go and store it in a database that is not properly protected, virus protected, etc. It doesn't help if you're storing it well, but then people can access it and transfer and email it and disseminate it without proper protocols. So you get the drift. This is very important. So the first thing is, am I dealing with personal information? The second thing is, when I process it, it's got to be protected from end to end. So colleagues, data subjects, your suppliers, your clients, your customers, your employees, they've got fundamental rights. The first one, to be notified that you have their information. So in other words, you've got to collect the information from the data subject, and they've got to be aware that you're collecting it. The next three have got to do with data subjects' right to participate in their information. In simple English, it means that data subjects are allowed to get hold of you, your information officer, and they are allowed to ask you, firstly, what information do you hold on me? I want to know all the information you hold on me. I want you to correct it, destroy it, delete it, or even object to you processing that personal information. So that means your information officer must be accessible to your data subjects. Then we have the right of the data subject, obviously, to complain to the information regulator if they're not happy with what you're doing with the information. So you might say to me, but John, now I understand the definition of personal information, and if I'm dealing with personal information, then POPIA applies. I also understand that I've got to protect the life cycle of processing. But how do I know if I'm doing it lawfully? That's the question that you need to ask yourself, and this is what you need to do in terms of testing whether you're compliant. Now, the POPIA Act, colleagues, has got 8 conditions for the lawful processing of personal information. In other words, if you don't comply with these 8 conditions, then you are processing information unlawfully. If you're doing it in accordance with this, obviously you are then processing it lawfully. So we don't have a lot of time today, but I'm going to take you very quickly through these 8 conditions, and I want you to do a self-assessment and say, in my environment, are we complying? So the first condition is accountability. Straightforward, self-explanatory. They're saying, because you're collecting information from your suppliers, your clients, your employees, you've got to be accountable. So don't come and tell us that you have had this information accessed by unauthorized people or lost or destroyed. You have to be accountable. The second condition, colleagues, you've got to limit the processing of information. And if you remember anything from today, you've got to remember what I'm sharing with you right now. I'm going to ask you a question. Let's say I'm from Standard Bank. I phone Precious. I say, hi, Precious, my name's John. I'm from Standard Bank. I want to know if Heidi is working for you. I need to know her job title. I need to know her earnings and how long she's been there, because she's applied for a loan and I need to verify her employment. Now, ladies and gentlemen, the question I ask you is Precious allowed to share with me, Standard Bank, Heidi's details? Now, in order to answer that question and almost any other scenario, these are what they call the justifiable grounds for processing. So the first thing Precious will say is, do I have consent from Heidi? In other words, has she given me permission? If you don't have proof of consent, the next stop is contractually. And what we always recommend is in your commercial agreements and your employment agreements, have a clause on POPIA that says that Heidi, by virtue of her employment, allows your organization to process her information. So that can be obtained contractually. But let's say she hasn't given consent, there's no contract. The next question then is Precious legally obliged to give Standard Bank Heidi's employment credentials? And of course, there's no legal obligation to do that. So ladies and gentlemen, this acronym CLIP, consent or contract, stands for the C. If you can prove that, well, then you can process the information. If it's legally required, so for example, if you've got to do a UIF claim or a COVID-19 claim, or if you've got to report to the Department of Employment and Labor or to SARS, you don't need to go and ask people if you can do that because it's legally required. Okay, so very important. Then the legitimate interests of the data subject. So if you are processing the information, you've always got to make sure their interests are central to that. And then finally, the police services and the intelligence agency, obviously they don't need your permission to go and investigate crimes. So ladies and gentlemen, I hope that that helps you. If ever you're confused, please do take note in respect of that. The third condition, purpose. You always have to ask yourself, if I process this information of this data subject, is it in line with the original purpose? If it's an employee, if I process it, is it in line with the employment relationship? If it's a supplier, is it in line with the original purpose? You cannot use the information outside of the original purpose. So you can't, for example, if you're providing motor vehicle service offerings and you service people's cars, you can't send those clients information to an insurance company to go and sell insurance to them, because that would be outside of the original purpose, unless, of course, they've agreed to that. Now, colleagues, on purpose, and this is what I want to touch on with you as SMEs in particular, my question to you today is, how long do you sit with personal information on your records, be it hard copy files or electronic files? Now, the reason for that is the POPIA Act doesn't mince its words. It says a responsible party, which is your business, you must destroy or delete a record of personal information or de-identify it as soon as is reasonably practicable after you are no longer authorized to keep it. So, ladies and gentlemen, very, very important is the POPIA Act says if you're holding information on current or past employees, current or past clients or suppliers, you have to destroy or delete it as soon as you're not entitled to hold on to it. Now, we don't have a lot of time today, but I've just included this slide because the first question you ask yourself is, if you've got a record on personal information, look at which statute or which law it falls within. If it's in the Companies Act, you've got to hold on to things for 7 years. Closed Corporations Act, generally 15 years. Then you get your Consumer Protection Act and your labor laws. But ladies and gentlemen, always remember, every year you should put time aside and say, do I really need to hold on to all of these particular pieces of information? The point being, if you're holding on to information beyond the duration that you are legally or contractually obliged to, and that information is hacked or lost or compromised in some way, you could face liabilities. Condition number 4, further processing. In other words, colleagues, if you've got suppliers, clients, and employee information, sometimes you use the services of external parties. So if you want to do a credit check or a criminal check on a data subject, you are sending a credit bureau, for example, their details. That's further processing. And once again, you're only allowed to do further processing if it is in line with the original purpose for which you collected that. You've got the consent of the data subject, unless it's in the public domain. So if you put things on Facebook or on WhatsApp, on Facebook or LinkedIn or any social media platforms, well, then you've got to accept it's in the public domain. Also, if things have to be processed in terms of law, obviously then you've got to comply with law. COVID-19 from a health and safety point of view, you've got to have mandatory screening of people that enter premises and work premises. That's required by law. And if you've got to report to the National Institute of Health, well, then so be it. The fifth condition, ladies and gentlemen, the quality of information. There's an obligation on you as the responsible party to have a process in place whereby you allow data subjects to update their information, or you yourself try and keep the information as accurate and complete as possible. The sixth condition, now this is also very important. If any of you have websites, or even if you don't have a website, but you need to look at POPIA from a contractual point of view, you need to have a privacy policy. And a privacy policy, colleagues, must cover these areas. The first thing a privacy policy must do is tell data subjects how you are going to be collecting, processing, and destroying the information. So a privacy policy in point A must say, at the very least, where you collect the information from and what you collect on those data subjects. Your privacy policy must also give your name and the contact details of your information officers so that data subjects can get hold of them if they have complaints or want to update the information. The third thing, point C, your privacy policy has to say what the purpose is of you collecting the information. What is the purpose? Is it because you run a medical practice or you run an accounting practice? But you've got to say what the purpose is. And then you've got to, in point D, say if the information is voluntary or compulsory so that data subjects can understand the consequences of a failure of them to share information. And then finally, the privacy policy must also have information if you are covered by any statutes or laws that compel you or allow you to collect that. Now, let me just emphasize once again, the privacy policy has to be on your website and referred to in your contractual documents so that when data subjects share their information with you, be it clients, customers, suppliers, or employees, you refer them to the privacy policy and say, by virtue of engaging with us, you accept these terms and conditions. So that's critically important. Then I started today talking about two sides of the same coin. And this is where I get it from, colleagues. The POPIA Act is very clear. It says to you, you must secure private and personal information. You must secure it. It's an instruction. And they even tell you, what needs to be done. They say you need to ensure technically that you are on track. In other words, your technologies, your platforms, your systems, your programs, that they are technically secured. Firewalls, antivirus, password protection, backups, you name it. Secondly, you've got to make sure your day-to-day organizational measures are also protecting personal information. Where do you store your files, your hard copies? Are they locked away? What are your employees doing in terms of using their cellular phones, their personal devices? Do they use it for work purposes? And if so, for example, what if they lose those devices? Do you have software that can remotely destroy company information and data subject information? So very important. And then the POPIA Act doesn't make a suggestion. They say, in order to achieve this, you've got to do what they call an impact assessment. So you need to go through an impact assessment to look at reasonably foreseeable risks. You then need to identify gaps and put safeguards in place and regularly update those safeguards. And very, very, very serious offense, colleagues, is if ever your data subject's personal information is compromised, you hacked, you lose information, it's, whatever the case may be. The POPIA Act says, look at the bottom of the slide, you have to notify the regulator and you have to notify the data subjects whose information has been compromised so that they can take steps to secure that. And look when you must do it, as soon as is reasonably possible, not within 48 hours, like with Liberty's case study. You've got to do it ASAP because people need to protect their assets and their information. You will be getting these slides, so I hope you're not trying to keep too many notes. And then finally, as I said, data subjects have the right to participate in the information. So you have to appoint an information officer. By default, ladies and gentlemen, the information officer is the chief executive or the highest ranking person in your organization or in your business. So if you're a sole proprietor or a CC, whatever the case may be, colleagues, if you are the highest ranking official, by default, you are the information officer, and you have to register with the information regulator. You are allowed to appoint someone else in your business as the information officer in writing and register them as well with the regulator, but it's got to be someone of at least a managerial status. Very, very, very important. So that is the POPIA Act in a nutshell. So what have we covered? The definition of personal information. If you're working with that information contained in that definition, POPIA applies to you. Now you've got to be on high alert and say, when I receive, store, process, transfer, destroy that information, I've got to make sure it's done lawfully. And then how do we know if it's lawful? Well, those 8 conditions for the lawful processing of personal information apply. In conclusion for today, before I look at the questions, I see there are a few questions in the chat box. I just want to say to you that this law is enforced through the regulator. The information regulator, of course, is the watchdog, the body that would take action against you if you fall foul of this particular act. By the way, the worst case scenario is 10 years of imprisonment and up to 10 million rand in fines. Now, I must tell you, fortunately, you'll only go to prison if you commit a criminal offense or you intentionally or willfully negligent. But other than that, you are open to fines, etc. And this enforcement committee at the regulator will do a lot of work in advising the regulator what action to take against perpetrators of this law. As I said earlier, you need to appoint an information officer. If you don't, by default, it's the chief executive or the highest officer, and you have to register with the information regulator. And then the information officer, if you ever wondered what on earth they must get up to, here are 5 key performance areas. They've got to establish a compliance framework, do an impact assessment, do your PIA manual, your Promotion of Access to Information Act manual. Small businesses have got a postponement to do the PIA manual until December this year. And then also the information officer must be able to process and receive requests for information from data subjects. And then just like I'm doing now, you need to do internal awareness sessions with your managers and staff to make sure that they are capacitated. And I think just finally, colleagues, before I look at the questions and Vicious, then I'll hand back to you after the questions, I want to just touch on direct electronic marketing. Now, very important. If you do any direct electronic marketing, such as faxes, SMSs, emails, ladies and gentlemen, you've got 3 conditions attached to that. The first condition is you will have to prove that you have received consent from the people that you're sending your marketing electronic communications to. So if you're promoting your products and your services and your solutions, you're going to have to prove, if someone challenges you, that they gave you consent. That's that part there. The second thing is you can only approach a data subject once to get their consent. If they tell you to get knotted, well, then you have to leave them alone. And then thirdly, each electronic mailer, each SMS, or whatever it is you use to do marketing, you need to have an opt-out option, which, as you can see, the POPIA Act says must be free of charge and simple. And that's why in SMSs and what have you, there's always an opt-out clause if you want to opt out. The only exclusion, colleagues, your customers that you had prior to the 31st of June, in other words, any customers you were already sending direct electronic marketing to prior to the 1st of July, you don't have to go back to them to get permission and consent. It's only from that date forwards. So, ladies and gentlemen, I hope that you found that interesting. What I can tell you, and of course you are going to be getting these slides, what I can tell you is there's an 11-point checklist. So, if you do want to check and see if you in fact are compliant, you're welcome to look at that. And then if you want to get some assistance, there is some marketing collateral at the back end. I'm not going to waste our precious time right now with that. So, Precious, I'm just going to look at the chat box. Let's see what's going on here. Right. What can we as SMEs do to protect personal information from cyber attacks? Yeah, 70% of businesses have been attacked. My recommendation, quite honestly, colleagues, is you've got to do what's fit for purpose, Richard. So, you're not expected to do what a bank would do in terms of the latest and greatest encryptions and technologies and who knows what not. But what you would be expected, Richard, is at least to have the bare minimum protections in place. So things like antivirus protections, if you are sending confidential information that's private or personal, you put in username and password protecting of documents as far as possible. Back up your information in secure places. So Richard, I just recommend you maybe get an IT person just to give you a sense of what is generally accepted practice. One of the big challenges, colleagues, is some companies are still working off very old Microsoft packages, and for obvious reasons, you can't always afford to update, but that's highly risky in that context. So I would ask Richard, maybe just get someone to give you a bit of advice on what is the bare minimum requirement there. But certainly in your emails, I'd look at Mimecast, I'd look at encryption when I send confidential stuff. Okay, ground rules. There we go. Thank you. You're very kind. Okay, and discipline. Heidi says, where can I get an example of a privacy policy? Well, Heidi, with Precious's permission, you're welcome to email me directly. Okay, I'm happy to send you one for free. My email address is at the very front of the slides. So if I don't mind sending you, one policy here, there, whatever. I want to help you as best I can. So just drop me an email, john@globalbusiness.co.za, and I'll send you a good example of one, right? Right, if you do training as a service, oh yeah, well done. Training's best. You take photos of participants and post them on your website and your social media. Are you covered by POPIA? Well done. So that's a good question. It's not only you for training. I mean, you often see businesses on their websites, they've got pictures of their employees, they're doing Nelson Mandela Day, and everyone's painting and doing stuff. Are you allowed to use those pictures? Very important, Lindiwe, only with permission. Just like we asked for permission on recording today, you're going to have to get permission. So you can get blanket permission in some instances. So for example, you could have a big sign at your entrance that says, by virtue of entering our training facility, you've got to understand and accept that this is what we do. I would certainly, if for employees or your delegates on training, Lindiwe, I would, when they sign, enrollment forms, I would have a little POPIA clause that says we reserve our right to use our pictures unless you object, to use your pictures in our marketing collateral. Very, very good question. Alfred says, if I take a picture from CCTV footage and place it on a board of a website for the public to identify in arresting the thief. Alfred, very good question. Remember, if it's a criminal matter where the police are involved and investigating, they can do it, right? But you can't necessarily take it into your own hands and proceed because that person obviously as yet is not guilty and what have you. Alfred, what you could do is you might have people who have an interest in that footage. They can come in, sign a non-disclosure agreement. You can show them the footage if maybe a cell phone was lost at a certain time and they want to see the CCTV footage, that's fine, but you're going to have to minimize it and control access as far as possible. Okay, very good question. Right, so Richard, you're most welcome. Precious, I'm in your hands. I think I've gone over my half an hour. Thank you.
Great. Thank you so much, John. I love the fact that you have tried by all means to meet our budget on assisting us to actually be able to do this in terms of the product. But I wanted just to go deeper on some of the questions. So some of our businesses run groups like WhatsApp groups where people can see each other's phone numbers. We don't have a control over what the person will do with that data, but our roles and responsibility might be fulfilled, but the people that are in that group might actually collect the data of the participants without even their knowledge. And I've seen this several times where I get added to some group and I don't even know what group is that, what is it about? How do we protect ourselves? And number two, I also just want to understand that as we're starting and we're building and we're going to have the manual deadline towards December, I think it's December. What are the things that we need to be thinking about to prepare towards that linen? I love your checklist. It gives us a clear structure, but is there any other things that we can start looking at? I'm also of a view that entrepreneurs, you gotta need to look at your business model and ask yourself on the business model whether these data that you are collecting either from suppliers or from customers or from even your employees, how well is protected, almost like do an IT risk assessment of saying that if I'm storing it on the cloud, how protected is that? If I'm storing it on some server somewhere, how protective is that? Can I get a certification? It's almost like you can't buy on a website that does not have a security on it. Actually, you shouldn't even be clicking on it because you don't know when you put your information in there, where does that data go, unless it's protected. So those are the things that I think if you can just go deeper on them, John, and we will also take more discussion. Entrepreneurs, please, this is your platform. We have booked John until past, so let's engage. There is so much information though, but thank you so much for very streamlined information that you've provided, John.
Thank you, Precious. So let's talk about WhatsApp, colleagues. Now WhatsApp, of course, when you sign up, you accept and have certain privacy settings, right? But when WhatsApp is used for non-personal use, so when it's not for domestic use or personal use, when it's used for anything outside of the first thing is, so when you use WhatsApp on your WhatsApp group, the policy. So as I say, on your WhatsApp group,
did we lose John? I think we lost John.
He's back.
Precious, can you hear me?
Yes, you are now back. We lost you for a few minutes there.
Yeah, sorry, man. So colleagues, as I was saying on WhatsApp, when you set up the group, you are allowed to include a 500 letter descriptor of the group. So what I would recommend is you use those 500 characters to put a little privacy policy in place, such as people have voluntarily joined. They understand that by joining the group, the information is in the public domain, that they undertake not to use information in a manner that is not allowed by the POPIA Act. They can exit the group at any point. So I would really recommend that your WhatsApp descriptor is used for a privacy policy, because definitely whoever establishes and administers that POPI group could be at risk if you don't have that privacy policy in that particular description. The second area, colleagues, is the Promotion of Access to Information Act manual, the POPIA manual. Now, I just want to pull up a slide very quickly because I didn't go through that slide, but if you take a look at this particular slide over here, if you process, because people often ask me, John, do we have to comply with POPIA? We're a very small company or small business. Do we need to have a POPIA manual? Now, the answer to that, colleagues, is if you process personal information, in other words, if you even process a bank account of a supplier, or if you're doing work for a client, you're processing information and POPIA applies to you. It doesn't matter how big or small you are. The only area, as I said, POPIA does not apply to is for domestic or purely personal use of information. Other than that, it applies. The second thing is when we talk about promotion of access to information, if you hold records like financial records, invoices, employment contracts, SARS returns, if you hold records, then POPIA applies to you. Thankfully, even though POPIA came into effect on the 1st of July this year in full effect, POPIA only comes into effect for SMEs on the 31st of December. So what I would recommend under POPIA, if you go and Google South African Human Rights Commission, POPIA manual, they've actually got a template that you could use. And you can use that template to start drafting your Promotion of Access to Information Act manual. It's a great template and you can use it. So colleagues, those are the two issues in respect of that. When it comes to checklists, so when we talk about IT and checklists, I would highly recommend that you take a look at your full enterprise, your IT architecture. Look from the programs you use, look at your email, where you back information up, external hard drives. Just, if you're storing information and backing it up in the cloud, there's another challenge, because if you're backing information up in the cloud, you've got to be aware where the cloud is. In other words, the POPIA Act says that, and I'm just going to pull the slide up, the POPIA Act says if you transfer information outside of South Africa, you've got to ensure that the recipient or the country that is receiving that personal information is at least subject to substantially the same protection as POPIA. So in other words, if you are using cloud service providers and they're backing your data up in Belgium or Germany or wherever it might be, in the United States, if you're doing that, you have the obligation to ensure that that destination country is also protected by law similar to POPIA.